circulating document asking that it be marked for identification. Your Honor, would this be marked as number 12 or?
Yes. The document that Mr. Risi just handed out is the second set, from the second set of the Consumer Counsel's interrogatories, question number 18. And the response, we'll mark it as Exhibit 12 and admit it into the record subject to further examination.
Thank you, Your Honor. Mr. Gaskill, did you help prepare the discovery response that has just been marked as Exhibit 12?
Yes, sir.
What is, we've talked a lot about it, but what is an installed dollar per kW cost? What does that mean?
So that's taking the capital cost you would be expected to spend divided by its capacity. In this case, it's overnight, so what we're doing is taking it back to real dollars, $2015. And what that allows you to do is get kind of the same, I'll call it currency. You know, when you have, say, a nuclear unit that's not going to be built to 2028 versus a solar, now you've got to get it all in the same year dollars. So that's what we mean by overnight installed cost.
Thank you. And does this response show the company's current estimates of the overnight construction cost for Remington solar, onshore wind, biomass, nuclear, and offshore wind?
It does, yes.
So at least looking at these different project types, the company estimates that Remington has a lower installed cost than the other renewables and low carbon facilities. Is that right?
That's correct.
And this is not on the discovery response, but where would a natural gas facility, either a combined cycle or a combustion turbine, where would it fall if it were on this table?
It's probably 850 to 900.
That would be for a combined cycle?
That's correct.
Would that be consistent with document that was just filed a few weeks ago in the Greensville case indicating that that project will be approximately $837 per kW?
You missed it a little high.
How about a CT, a combustion turbine? Where would that fall on this chart?
It would be in ballparking, say, 450 to 500.
All right, if you added a coal facility to this chart, where would it fall?
I'm not real sure without my IRP. It's listed in the IRP. I can look it up, but I'm not sure.
Would you accept, subject to check, that the last coal-fired power plant built in the Commonwealth was the Wise County power plant with an estimated cost of $1.8 billion, nominal rating of around 600 megawatts, and would that cost be around $3,000 per kW?
Yes.
And do you think the cost of coal facilities, the overnight installed cost, has gone up or down since that time?
Hard to say because we can't build them anymore. I'm not really sure. Nobody builds them.
Can you just elaborate on that point?
Because of the new environmental rules, the new source performance standards essentially prohibit any new unit that has a carbon intensity, I believe it's over, say, 1,100 pounds per megawatt hour, which a coal would not meet.
All right, last question on this topic. Why is the Remington solar facility $2,266 instead of the $2,350 included in the initial application?
Again, that's just discounting. So the 2350 is the nominal. So you've got some spends in 15 and you've got some spends in 2016. If you discount that back to $2015, you get a little bit lower cost. Again, just as a way to compare the different technologies on the same year dollar basis.
it has not been an updated cost estimate?
This was still based on the 2350, the original filing. It's just putting it in 2015 dollars. But my understanding, and maybe Mr. Mitchell will elaborate, I think there have been some changes to the costs that have come down, but he can elaborate on that.
That's not what's reflected in
That's
your
what's right.
discovery response.
That's
Thank you. Another document. I have another document I'd ask if it could be marked for identification purposes and admitted into the record subject to cross.
Mr. Lucy is handing out the staff's 10th set of interrogatories, question number 36, and its response. This will be marked as Exhibit 13 and admitted into the record subject to further examination.
Mr. Gaskill, do you have what has been marked and admitted as Exhibit 13 in front of you?
I do.
Is that a discovery response that you prepared or helped prepare?
It is.
And Your Honor, just for the record, the FERC order that's referenced in this question, the citation is 151 FERC, F-E-R-C, 61,208. And Mr. Gaskill, I don't mean to scare you with the legal citation. I don't plan to get into the details, but I do want to ask you some questions about the capacity market and how PJM's changes have affected the company's assumptions, okay?
Sure.
Now, for a facility to count as a capacity resource which can be used to satisfy capacity obligations, is it generally true that the company needs to bid that facility into and clear an auction that's run by PJM Interconnection?
Yeah, to count it as a capacity resource in the PJM capacity market, you would bid that into the auction.
And you would need to clear that auction?
Correct. Right.
And the PJM capacity proposal that your testimony identifies and which FERC has now approved in large part, how does that affect the company's thinking about whether Remington would be a resource that the company would bid into those capacity auctions?
Great. So the proposal by PJM and approved by FERC, they're still figuring out how to implement it and some of the rules and tariffs around it. But essentially what the capacity performance market does is largely a result of the polar vortex events of the 2014, where they got dangerously close from not having enough capacity in the RTO to meet load. And so, I'm paraphrasing, but essentially what they've done is they've said, for you to be a capacity resource, we need you to be available when I need you and for as long as we need you, or you will be subject to penalties during peak hours if you are not available then. So taking that, obviously solar or any intermittent or energy limited resource is challenged by those rules, to where you would be subject to pretty draconian penalties if the generation is not there during a peak event.
And is it fair that the company will have to evaluate the capacity rules and weigh the draconian penalties or other risks against the potential rewards of bidding a facility like Remington in to decide whether or not to do that?
That's correct, yes. So what we've done, and maybe I didn't answer your prior question, but what we've done for Remington is we're, instead of connecting it at the transmission level, we're connecting it at the distribution level, which effectively will reduce the net load on that distribution circuit. So from PJM's eyes, they don't really see the generation from this unit. It's just less load going onto the transmission system. It's still a generating resource, it's still a supply side resource. It's just not directly in PJM. And so the result is that PJM will see, as this is generating during the summer months, which is what they use to do their peak load forecast, as this is generating, it reduces the net load that PJM sees on the transmission grid, thus reducing our capacity obligation. So in other words, going to have to purchase less capacity in PJM as opposed to bidding it in and getting the revenue back.
And that's the load reducing benefit that you identify on page 12 of your direct testimony, is that correct?
Yes.
Now, you also indicate that it will contribute 44% of the nameplate capacity. Is that, I think someone said earlier today, that's the expected generation capacity factor of Remington during summer hours, is that?
Right. So what we did is we looked at, so it's a 20 megawatt facility, we looked at the expected generation during June to August hours, 2 p.m. to 6 p.m. and said, what is its expected generation going to be, based on sunlight and the tilt and orientation at that particular site. And so our expected generation across those hours, which is what PJM generally uses to do their load forecast, is going to be about 44% or 8.7 megawatts of the 20 megawatts. So that's how much you would expect on average over time that the load to PJM will be reduced. And therefore, our capacity obligation would be reduced by that amount.
And those peak hours that matter for purposes of PJM and PJM's capacity obligations, do you know those ahead of time, or do you find out about those later?
Talking about the, say that again, I'm sorry.
Can Dominion forecast exactly when the peak hours are going to be that matter for purposes of determining what the company's capacity obligation is? Or is it a matter of, after a year is through, PJM planning or whatever, PJM or Dominion looks back and identifies, say, a handful of hours?
I think it's more of the latter. If you're talking about the load forecast going forward, you're not talking about the CP peak event hours, you're talking about how is the load forecast generated.
Well, let me start off.
I'm sorry, I just want to make sure I'm
Yeah,
understanding what you're asking.
and my questions weren't clear. I'm trying to, let's use your chart here. Mr. Gaskill, filing schedule 46A, those are your initials up above that, is that correct?
Yes.
Statement 1, page 2 of 2. And the number 9 down across the line that says Remington Solar Facility that then decreases to 8, do you see that?
Yes.
Is that essentially 44% of the 20 megawatts?
Right.
So is this a figure that's intended to show the load reducing effect that your testimony discusses?
Yes.
And do you know for a fact, like in 2021, that the facility will effectively count as a 9 megawatt load reduction?
Yeah, what we're looking at is we know currently PJM does their load forecast based on the summer peak hours. And so what we've looked at is what is the expected generation of this facility going to be in those summer peak hours. And that would be your expected reduction in your capacity obligation as they do their load forecast going forward.
And I think your discovery response, which is Exhibit 12, indicates that the company's assumptions about this have not changed, at least based on its initial assessment of the relevant FERC ruling. Does that continue to be the company's position, having now had a few more weeks to review the
Yeah, we still think at this time for this project it makes sense to treat it as a PJM load reducer as opposed to bidding it into the capacity market and subjecting to those CP penalties.
And I think you've used the word intermittent and maybe energy limited resources as ones that are bearing the risk associated with the new rule. Does that mean that it's not necessarily all renewables? Could there be renewables like a biomass renewable facility that is maybe not intermittent, that is dispatchable, that would not be bear the same risk of bidding into?
It would still bear some risk, but it wouldn't bear the same risk.
believe that's all I have. Thank you.
Mr. Rusi. Mr. Reed?
Very briefly, Your Honor. Mr. Gaskill, I'd like to ask you just a couple of follow-up questions to the exchange that you had with Mr. Rusi on behalf of the Division of Consumer Counsel on the subject of third-party market alternatives, and specifically why the company did not conduct a formal RFP for the Remington project. All right, sir?
Mr. Reed,
Mr.
I assume you mean the exchange with Mr.
Oh, I'm sorry,
Reisinger.
Reisinger. Pardon me. Reisinger, Rusi, and Reed. Yes,
Yes.
with the AG, right? And I don't want to put words in their mouth, but as I understood the opening statements of Mr. Green and Mr. Jaffe, their clients in this case do not oppose approval of the Remington project. Mr. Jaffe said some nice things about the Remington project, but they both believe that an RFP should be conducted going forward to help the company, meet the 400 to 500 megawatt goal that it is set internally, and that the General Assembly has expressed in the law now. Do you recall that testimony?
That appeared to be their statement.
Statements, not testimony. So just so I'm clear, based on what you've testified to live here today and what Mr. Rogers has testified to live here today in this proceeding, is that sort of precisely what the company intends to do at this point?
That's correct. I mean, given the state of the Virginia utility scale solar market at the time of this, we felt that wasn't an appropriate way to evaluate actual market alternatives, which is why we went to North Carolina, where they do have a very active market. But now what we've seen is, since we've announced this project and shown a commitment to solar, as well as the General Assembly declaring up to 500 megawatts of utility scale solar in the public interest, what we have seen is a maturing of the Virginia utility scale solar market. So you see a number of projects out there under development now. So at this time, yeah, we do feel that an RFP going forward would be an appropriate way to do that.
And that was going to be my next follow-up question, Mr. Gaskill. As opposed to several months ago when the company was contemplating the Remington project, do you believe that the General Assembly's recent enactment of amendments to Title 56 to declare up to 500 megawatts of new solar generation to be in the public interest has changed the market for solar developers in Virginia?
It definitely has. We've seen a number of projects, developers in particular, approaching us about interest in their project.
And likewise, do you believe that the company's application to construct Remington and this project being in the queue has changed the market for third-party developers in Virginia?
Absolutely.
Thank you. That's all I have, Your Honor.
All right, thank you, Mr. Reed. And thank you, Mr. Gaskill.